Today we're revisiting one of the most common and most misunderstood questions I hear from clients. How can I legally avoid paying child support? My name is Kyle Kaufman. I'm an attorney at HKK Law Offices and we're based in Wisconsin. Now, before I jump into this video, I really want to be clear with you that this video is not about dodging your responsibilities as a parent. If you're raising a child, you should be contributing to that child support, and you probably should want to do that as well. But what many people are trying to avoid is something different, and that's unfair child support amounts. Rigid payment plans that don't reflect reality, or court orders that don't match their actual parenting time or their financial situation. So today, what I want to do is give you 4 practical strategies to minimize or eliminate formal child support while still doing the right thing for your child. And I call that the 4 C's. Let's walk through them one by one. The first C is to consult. All right, talk to a family law attorney. If you're serious about figuring this out, the very first thing you need to do is sit down with a qualified family law attorney, someone who understands child support law in Wisconsin. Now, I can hear a lot of you saying already, hey, lawyers don't help, they're just part of the system. The fact is that you can learn and become educated by talking to lawyers and doing these consultations. Now, we offer free consultations at HKK Law Offices, and we encourage anyone that has a child support concern to take that step and to contact us. And I'll tell you why. In Wisconsin, child support is often calculated. It's by using a formula, percentage of income. For one child, it's 17% of gross income, 2 kids, 25%, 3 kids, 29%, and so on. But that's just the default. If you and the other parent have shared placement, the formula changes again. If you're self-employed, the court may need to estimate a fair income based on business expenses. And if your child has special needs, or if you have multiple families, that changes the equation too. A good lawyer will look at the big picture, and a good lawyer will say, here's how support would be calculated in your case, and here's where we might deviate in your situation. Now, maybe you earn less, but you have the child 50% of the time. Maybe you pay health insurance and provide transportation. Those things do matter. They're financial support. So before you make assumptions based on a Google calculator, talk to someone who knows these rules and actually has applied these rules in Wisconsin courts. And it can save you lots of time and lots of money and give you peace of mind. What I have learned that the most important reason to consult with a lawyer is to tell the attorney about your situation. Every person's life is different, and you meet the attorney at your level. And what I mean by that is that you come to the attorney with a background of events and knowledge. Things have happened in your life and with your family that are unique to you, your family. And you probably have some general knowledge about child support. You've researched it, you know what you want, and some of you have lots of intention and lots of knowledge. But what do you really know, and are your expectations reasonable? So at a consultation, an attorney like me can listen to you and discover more about you. That gives the attorney context. When you state what you want, an attorney can tell you how reasonable those expectations are. I've seen people acting without attorneys and taking actions and seeking outcomes that are simply not realistic. For example, if you're a person who was working and support was set on your income from your employment, and then you later lose that job, what are your expectations of what happens next? It's a question for you. What happens when you get a new job? What amount of income is used for support? When do you bring a motion to modify support in a scenario like this? Now, some people think that losing a job is all that matters. I lost my job, and now support should change. But we have to ask, why did you lose your job? Were you terminated? Did you contribute to the loss of your income? And if you are a person who simply thinks that changing employment and earning less money means that you are able to pay a lowered amount of child support, then I would challenge you on your expectations. You have to dig deeper. It's more complex than that. And that's why at a consultation, a lawyer is going to listen and give you feedback. And you want to talk to at least 3 attorneys. It's really important. You need to learn more about your situation and whether your actions and expectations on those results align. And by meeting with at least 3 attorneys, you can get more certainty on that. Now, the second C is about communication. After you understand your rights and options, the next step is to talk to the other parent. This part can feel uncomfortable, but it's often the key to avoiding court-imposed child support orders. Whether you're getting divorced, reviewing an old judgment, or you've never been married to the other parent, the principle really is the same. If the two of you can reach an agreement that meets your child's needs, the court will often accept that agreement, and that's even if it's different from the standard formula that's used here in Wisconsin. Now, communication doesn't mean confrontation, right? It doesn't mean making threats or demands. It means asking thoughtful questions, listening to the answers, and sharing your ideas respectfully with the other parent. So you might say, what do you think? What do you think would be fair given how we're splitting time with the kids? I want to make sure that we're both contributing, but I'd like to avoid a rigid court order if we can agree. Now, that kind of approach can open the door to discussing who covers insurance, who pays for daycare, or extracurricular fees. You could have discussions then about rotating claiming the child on your taxes to get the tax dependency exemption and the child tax credit. And these conversations can be tough, but if they work, then they can save you months in litigation and thousands of dollars. And courts just generally will support an agreement of the parents if it makes sense. Now, I worked with a client who wanted to work with the other parent on ways to avoid traditional child support orders. And a wise friend of mine once said that what makes it on the page makes it on the stage. So I thought about that with this client and employed that thought, right? And put that into action. So I said, let's write down what you want and how you want it to work with the other parent, and then let's financially find ways for both parents to financially support the child without a traditional child support order. And that's what we did. We wrote it down, we shared our written thoughts with the opposing party, and guess what? The opposing party read our thoughts, considered them, and replied. The reply was positive. The other parent had some ideas about financial support, and ultimately, after exchanging written proposals, the two parents ended up signing a written agreement that resolved their financial support differences. It's called a stipulation in order. And we presented that written plan to the court, and the judge approved of it. Now, part of communication that I think is really important is to listen. And now this might sound very simple to you, but it's one of the most powerful tools you have. Too many people walk into a negotiation and they're ready to pitch their perfect plan, but they skip listening. And that's a really big mistake, so don't do that. Now, often the other parent's expectations can be lower than yours, and so don't assume that it's going to be the worst thing. They may be open to flexibility, and they may prefer creative solutions just like you. So before you jump in with your proposal, ask, what's your biggest concern financially? What would make this easier for both of us? And when someone feels heard, they're able to come to the table, they're far more likely to collaborate. And that trust that you've built up by inviting them to share their thoughts can lead to agreements that then minimize or eliminate formal support. Now, listening doesn't mean agreeing with everything. It just means gathering information before you react. And if you do that well, you stay in control and you shape a better outcome for yourself. Now, I have an example of how to listen first. And with this client, we discussed several potential outcomes. I worked with my client to anticipate what the other parent might suggest, and of course filled my client in about what the law might say in a situation like this. The client and I decided to start the negotiation, and I was authorized to submit our offer verbally to opposing counsel. This person had an attorney. And I started the conversation by suggesting to opposing counsel that instead of talking about the numbers and submitting our proposal, I just kind of came in and said, wow, this is really a tough one. I just don't know how we can resolve the child support issue. And that opened the door. And I asked the attorney, I said, do you have any ideas? And frankly, it was the best question I asked that day. The attorney had an idea, and that idea was to resolve the case. And that idea was, frankly, much better than what my client had authorized me to suggest. Now, the attorney communicated the offer. I hemmed and hawed a little bit, and I said I need to get back to you with my client's consent first. So I spoke to my client, who was, of course, thrilled with this offer, and we accepted it. The point is that fear cannot stop you. A lot of times we fear the worst, and if we allow our fear to lead us, then we would have made an offer that matched our fears, right? We would have come in with trying to minimize what we thought was going to be the worst case scenario. Instead, we relied on faith. Faith that there was a fair and just answer out there, that the other party also had solutions. So we asked the opposing party what they wanted, and by being open-minded to someone else's ideas, we'd reach an outcome that was favorable for that client. So the third C in this is to be creative. And that's when you start brainstorming alternatives to a traditional monthly child support check, right? Just writing the check and giving it. We've talked about some of that so far in this video, but in Wisconsin, if both parents agree and the plan meets your child's needs, the court can approve these deviations from the standard formula. Some examples I've seen work is where one parent is paying for health, dental, and vision insurance, or parents split school or activity costs. One parent covers childcare while the other then claims the child on taxes. I've seen parents alternate covering clothing, school supplies, or travel expenses. A quick story that I can share with you is having a client that this person had equal and shared placement, some people call it 50-50, and the person had modest income. And rather than paying $400 a month in cash, what this client agreed to do was to cover the daycare and insurance. And that deal saved that client a lot of money. It worked for both sides and the judge approved of it. Now, that's child support, but it's creative. It's tailored support, and it's only possible when you've consulted, communicated, and listened. So don't just think about writing these checks or automatic transactions from your checking account and into the system and to the other parent. Think about solutions that don't actually require the exchange of money. Now, being creative can get you what you want, and two parents who sit down and exchange those ideas and agree on a creative plan is better than attorneys and judges deciding for you. They're really strangers, right? And you know what's best for your kids, and you know that better than attorneys and judges. So attorneys and judges will give you their opinions, and they'll tell you what you could get or not get. But their opinions are not a substitute for two parents working creatively to come up with a plan for child support. If your goal is to avoid a traditional support order, how can two parents make sure that they're each contributing? That's a key question, combined with questions about your child's needs, can help with creative solutions. Think about things like this. What age is your child? And what does that child need at that age? A 10-year-old, for example, obviously needs shelter, food, clothing, transportation, and medical care at a minimum. But what is each parent paying for that? Put some numbers on that. Does each parent provide equally on their own without exchanging money? And what else does a 10-year-old need? At school supplies, extracurricular fees, gifts for birthday parties for friends, uninsured medical expenses, entertainment, things of that nature. And how can the parents then come up with ways where each parent can contribute financially or provide service to equalize things? For example, could one parent do all the transportation for school and events for the child, while the other parent actually pays the costs and fees for extracurricular fees? Would that be fair? Could be in your situation. What about where one parent is paying for uninsured medical expenses and we have the other parent who actually attends the medical appointments? Would that be fair? It could be, right, if you talk about it. Now, the answer to my questions are really for you and the other parent in your case to decide and agree upon. But I'm suggesting ways that you can offset that, right? And go to the other parent and have these conversations. So there's many ways on how to creatively make it work with money actually exchanging hands. But you need to think about it. You need to spend some time thinking about it. And I have seen it work. I've seen attorneys and parents come up with really creative ways to do this, and they avoid a formal child support order that is simply a check. Now, the possibility of that, though, gets lower if you come before a judge, because judges are going to give you objective outcomes based on standard guidelines and principles. The judges just simply don't want to go too far afield from the norm, right? So if you're before a judge, that's where it becomes difficult. And that really leads me then to my final C, the fourth one I have for you, and I call it certainty, okay? Certainty. So certainty brings this all together. And another way to say it is control. I like certainty because if you and the other parent don't make a plan, then the decision lands in someone else's hands, ultimately a judge. And judges are smart, they're fair, they're well-meaning, but they really don't know your family like you do. They're making decisions, it's based on a 30-minute hearing, maybe an hour long, and they have a stack of papers electronically, a lot of cases coming before them. And once the decision is made by the judge, it can be hard and expensive to change. And it just kind of sticks, right? And oftentimes doesn't feel good. And that's why these 4 C's matter. When you consult, you communicate, listen, and create, you control the outcome. But when you wait too long, you lose that certainty. If you go to court, you want to have a hand in the outcome. So I don't want you to think that once going to court, you have no control at all. You want to create as much certainty as possible. And the way that you do that at that point is to become prepared. Present your case cleanly, right? You want to give yourself the best chance to get an outcome that is certain to you. So share the information you have on your income, on your expenses, on your assets and your dets. And you want to know your numbers really well. And you want to know the other parent's numbers too. Don't forget that. You need the data on the other parent's income, their assets, debts, and expenses. And you need to be able to explain it in a way to the court what those numbers mean and why your interpretation of the numbers is correct for the outcome that you desire, which could be no support, a smaller support amount, just something that you think is reasonable and fair and in the best interest of your child. And it requires some financial literacy, frankly. So again, you need to do your homework. You need to think. You need to become educated. You need to know how to read an income statement, how to read a pay stub. Have you ever actually read your tax return? Read it. A profit and loss statement if a business is involved. These are just some of the things that you need to be able to read and understand. And you need to know the difference between concepts like gross income and net income and understand how and why that matters to the court in Wisconsin. You need to know and explain to the court how many children are involved in your case and what the placement schedule is for the kids, because that matters on what a child support order could be. You need to tell the court what you want and why the court should do that and adopt your plan. And the plan needs to be grounded in the facts that we've just talked about and in the law. So think of it this way. If you want to travel somewhere, now you get there by picking your destination first. You think about the mode of travel. You think about the lodging, what you'll do when you're there, and you'll research all those things and the cost to do that, and then you're going to fit that into your budget and say, is this affordable or not, right? That's how we choose. Airline tickets, the price of the hotel room or the VRBO, and that's all based on what you know. So know your situation too. So when you come into a child support hearing, know where you want to go with your case, the outcome, explain it to the court, how the data and the facts of your case support your position. Give yourself certainty. And if you simply show up to court and you hope that the opposing party is going to plan that for you, or that the judge has a specific plan for you, then you're really playing with fire. If you leave it to the others to plan for you, you're likely to find yourself taking a trip to a place that you don't want to be and getting there in a way that you don't want to and staying somewhere where you're really uncomfortable. So you'll end up spending money and in a way that you don't like it. So create that certainty for yourself, just like planning a trip. When you go to a courtroom, you want to plan that outcome down to a T. So remember, these 4 C's are really important to you. Consult with an attorney who understands Wisconsin law. I suggest at least 3 attorneys. Communicate with the other parent in a respectful and problem-solving way, and remember to listen, okay? And listen to what the other side is offering to you. The 3rd C here is to be creative and come up with support arrangements that reflect real life and could result in a non-formal child support order. That's fair. And finally, you want to create certainty of the outcome, and you want to do that before someone else decides it for you. Now, here at HK Law Offices, we help parents just like you, and we do that every day. And we've been doing this for many years now. Parents who want to do the right things for their kids, we love working with you. We don't want you to overpay for support or get lost in the court system. So if you're going through a divorce, facing a child support order, trying to modify an existing judgment, don't wait. Simply call us, schedule a consultation with one of our attorneys, and we'd be happy to talk to you about your situation. I really appreciate you watching this video, and I hope that it brought value to you, some clarity to your situation, and makes you feel a little bit more calm about what you're facing. If you liked what we are doing here, if you could please subscribe to our channel, like the page, and leave a comment. We'll see you next time. Thank you.